Welcome to the 19th almost annual Hindelang lecture. I'm Alan Lazat, the Executive Director of the Center of the Hindelang Criminal Justice Research Center that's housed in the School of Criminal Justice. The center supports research activities in the school and is named after Michael Hindelang, a prolific and pioneering criminologist at the school who founded the Criminal Justice Research Center, as it was called in the late 1970s. He passed away at a very young age, and since 1984, the center has been on campus and bears his name. Before we begin, I'd like to thank the administrative director of the center, Michelle Ellis, and the secretary of the center, Kathy Grabert, for their work on organizing this event. And also, much credit is due to Dr. Gisa Lopez, the executive director of the New York State Youth Justice Institute, also housed in the center. And thanks to her staff fellows, Brian Rainey and Alicia Gagnon, for their incredible support in making this happen. If anything goes wrong today, it's my fault because I'm an electronic dinosaur. Jim Diaz, the university's at Albany's Vice President for Research, is here today to introduce our guest speaker. He's been very supportive over the years of the center, of me, and of my own research, and I greatly appreciate it. So Jim, could you introduce our guest?
Sure, thanks, Alan, and thank you for your leadership over the years of the School of Criminal Justice and your continuing support of the school. So it's my pleasure today to introduce to you all here Dr. Cassia Spohn. She's a foundation professor, a Regents professor, and former director of the School of Criminology and Criminal Justice at Arizona State University. She received her doctorate in political science from the University of Nebraska at Lincoln, and she's the author or co-author of 7 books, including Policing and Prosecuting Sexual Assault Inside the Criminal Justice System. This was published in 2014. She's published more than 150 scholarly papers, and she's received more than $6 million in funded research support. Her research interests include prosecutorial and judicial decision-making, the intersectionality of race, ethnicity, crime, and justice, and sexual assault case processing decisions. While her research is always theoretically informed and methodologically sophisticated, it also has very broad implications for policy and the practice in the criminal justice arena. In 2013, she received the Arizona State University's award for leading edge research in the social sciences and was selected as a fellow of the American Society of Criminology. She is also a fellow of the American Academy of Criminal Justice Sciences, and I note that she was given, that was in 2017, and in 2018, she was given the Evelyn Gilbert Unsung Hero Award, the Minorities and Women section of the ACJS. And she's also a fellow of the Western Society of Criminology, and again, I noted that she was given this notable award for significant contributions to scholarship or activism on the intersection of women and crime. So we're really very proud and privileged to have Dr. Spohn here today, and for her scholarship that is really teaching us about this particular aspect of criminology and social justice. And I should say that on the national level, in 2017, she was appointed to the Department of Defense Advisory Board on investigation, prosecution, and defense of sexual assault in the armed forces. So really very privileged to have you here today, Dr. Spohn, and without any further delay, I'll turn the podium over to you.
Thank you, Jim, for that very kind introduction. And I am absolutely delighted to be here today. Thank you very much for inviting me. And I'd like to spend a little bit of time talking to you about some of the findings from my study of policing and prosecuting sexual assault in Los Angeles. First, a little bit of background. In 1975, Susan Brown Miller wrote a detailed and sobering account of rape, its origins, the myths surrounding it, and the ways in which laws and practices made it likely that only a few of those who committed this crime of violence would be held accountable, and that those who were held accountable would not be representative of the many who engaged in this type of criminal behavior. 12 years later, Susan Estrich, a law professor and the author of Real Rape, reached a similar conclusion. She, like Brown Miller and others, argued that all rapes are not treated equally, and that the response of the criminal justice system is predicated on stereotypes about rape and rape victims, and that the most serious dispositions are reserved for what she called real rapes involving genuine victims. These feminist critics, and there were many others as well, argued that under traditional rape law, it was often the victim who was placed on trial. Criticisms such as these led to a rape reform movement that emerged in the 1970s and quickly became a key item on the feminist agenda. Women's groups led by the National Organization of Women's Task Force on Rape lobbied state legislatures to revise antiquated rape laws that too often place the blame for the crime on the victims. They were joined in their efforts by crime control advocates, notably police and prosecutors, who were alarmed by dramatic increases in reports of rape during the late 1960s and early 1970s, and who urged rape reform as a method of encouraging more victims to report to the police and to cooperate with criminal justice officials. And together, these two groups formed a powerful, although perhaps ill-matched coalition for change. And by the early 1980s, nearly all states had enacted some type of rape reform legislation. So the changes that were enacted by the various states varied, but the 5 most frequently enacted changes included redefining rape and replacing the single crime of rape with a series of gender-neutral graded offenses that were defined by the presence or absence of aggravating circumstances. Second, changing the consent standard by eliminating the requirement that the victim physically resist her attacker. Third, eliminating the requirement that in order to convict the defendant, the victim's testimony had to be corroborated. Fourth, eliminating the marital exemption for rape, which was enshrined in the traditional common law definition of rape as carnal knowledge of a woman, not one's wife. And the final prong of the reform movement was the passage of rape shield laws that precluded the defense from introducing testimony of the victim's prior sexual conduct with persons other than the defendant. So clearly, these statutory changes were designed to encourage more sexual assault victims to report their crimes to the police and to enhance the likelihood of arrest and successful prosecution. However, as we know from decades of legal impact research, changes like these are not necessarily implemented as reformers intended. Moreover, changing the law does not necessarily mean that you will change the attitudes and the behavior of victims, police, prosecutors, judges, and jurors. In fact, that is exactly what Julie Horney and I found when we investigated the impact of the rape reform movement in 6 major urban jurisdictions. And it's interesting, I just recently found out that Julie Horney actually gave the first Hindelang lecture, and of course she was the dean of your school for a number of years. What we found was that the definitional and evidentiary changes produce symbolic but not instrumental effects. These changes refuted antiquated notions regarding chastity and the willingness of women to lie about being raped, and perhaps led to more sensitive treatment of victims. But they did not lead to increases in the odds of reporting, arrest, prosecution, or conviction. So let's fast forward to the 21st century and an NIJ-funded study of policing and prosecuting sexual assault in Los Angeles that I conducted with my colleague, Catherine Tellis. The overarching question that we wanted to answer was this: 3 decades after the rape reform movement, had things changed or had they simply remained the same? So as I said, this was an NIJ-funded mixed method study focusing on both police and prosecutorial decision-making. So we had quantitative data on all sexual assaults that were reported to the Los Angeles Police Department and the Los Angeles County Sheriff's Department over a 5-year period. And then we also received complete redacted case files for a stratified random sample of sexual assaults reported to these 2 law enforcement agencies in 2008. And this was just under 1,000 case files. And some of these were 20, 30, or 100 pages, or sometimes longer. And then we conducted interviews with detectives from the 2 law enforcement agencies and with LA County deputy district attorneys. So just over 100 interviews total. What I'm going to talk to you about today is 2 different research projects that resulted from this larger project that actually resulted in the publication of the book that Professor Diaz referenced. The first is a study on unfounding sexual assault that was published in Law and Society Review. And the second is a study that looks at the overlapping police and prosecutor decisions that was published in Justice Quarterly. So in June of 2020, the Baltimore Sun reported that the Baltimore Police Department led the country in the percentage of rape cases that were deemed to be false or baseless and thus were unfounded. According to the report, from 2004 to 2009, 1/3 of all the rapes reported to the Baltimore Police Department were unfounded. And this was a rate that was 3 times the national average. Also in June of 2010, the New York Times reported that New York Police Commissioner Raymond Kelly had appointed a task force to look into the handling of rape complaints and to recommend new training protocols for dealing with victims of sexual assault. And the review was prompted by complaints from rape victims who said that their allegations of sexual assault were either unfounded or downgraded to misdemeanors. These news stories, along with others regarding the mishandling of rape cases in cities such as Milwaukee, Cleveland, New Orleans, and Philadelphia, culminated in a September 2010 United States Senate hearing that was convened by then Senator Arlen Specter to examine the systematic failure to investigate rape on the part of police departments nationwide. And testifying at the hearing was Carol Tracy, the executive director of the Women's Law Project, who said, "It's clear we're seeing chronic and systemic patterns of police refusing to accept cases for investigation, misclassifying cases to non-criminal categories so that investigations do not occur, and unfounding complaints by determining that women are lying about being sexually assaulted." Allegations that women are lying about being sexually assaulted are not new. In fact, Sir Matthew Hale, an English judge, opined in the 17th century that rape, quote, "is an accusation easily to be made and hard to be proved and harder to be defended by the party accused, though never so innocent. In fact, in many jurisdictions, judges were required to include a cautionary instruction in rape cases, warning jurors about the dangers of false reports. So estimates of the number of false reports vary widely, with some studies concluding that the rate is 30 to 40% or higher, and others concluding that it's actually 2% or lower. But according to Longsway, Archambault, and Lisek's analysis, studies that use appropriate research designs suggest that the rate of false allegations ranges from 2% to 8%, so a relatively low rate. So first, a little bit on FBI guidelines on case clearances. So a case can be unfounded according to the Uniform Crime Reporting Handbook only if it is determined through investigation to be false or baseless. Although these terms are often used interchangeably, they don't mean the same thing, certainly not in the context of the UCR guidelines. A false report is one in which the victim deliberately fabricates an account of being raped. For example, a teenager who misses her curfew because she's out partying with her friends. And when she gets home, she tells her parents that she was abducted by a man in a white van, taken to a motel, and sexually assaulted. This was actually one of our cases in Los Angeles. By contrast, a baseless report is one in which the victim recounts an incident that, while truthfully recounted, does not meet the legal definition of a sexual assault. An example of this would be a situation in which the complainant believes that, quote, something happened while she was passed out at a party or asleep, but the police investigation uncovers no forensic evidence or other evidence that a crime was in fact committed. So the purpose of this particular study was to evaluate sexual assault cases that were actually unfounded by the LAPD. And there were 81 of these cases. And the question we asked, based on our review of these cases, is, were the unfounded complaints actually false or baseless allegations? And second, we wanted to know what factors predict unfounding. So based on our case review, we categorized the 18 unfounded cases as a false report, a baseless report, or not a false or baseless report. Within the false report category, cases were subdivided into, first, cases in which the complainant recanted and there was evidence to support a conclusion that a crime did not occur. And second, cases in which the complainant did not recant, but there was either evidence that the crime did not occur or no evidence that the crime did occur. Regardless of whether the complainant recanted, in other words, we looked for evidence that would support a conclusion that a crime did not occur. This might be witness statements, video surveillance report, evidence, or physical evidence that clearly contradicted the complainant's statement. In one case, for example, the complainant reported that she was abducted from the parking lot of a fast food restaurant, but video surveillance did not record anyone being abducted during the time frame provided by the complainant. In another case, the complainant said that she called 911 and reported that she had been sexually assaulted, but there was no record of the call. The second category of unfounded complaints is cases that were determined to be baseless. So included here were cases in which complainants believed that they might have been sexually assaulted while they were sleeping, under the influence of drugs or alcohol, or as a result of a mental illness. And these cases were unfounded when the forensic medical exam revealed no physical evidence of a sexual assault, or witnesses testified that an assault did not occur. The not a false report category was also subdivided into two categories. First, cases in which the complainant recanted, but there was evidence that her recantation was motivated by fear of retaliation by the suspect, pressure from the suspect or the suspect's family or friends, or simply a lack of interest in proceeding with the case. The second was cases in which the complainant did not recant. There was evidence that the crime did occur, but that prosecution would be unlikely because of things such as the complainant's behavior at the time of the incident, her lack of cooperation, lack of corroboration or inconsistencies in her statement. And these factors were noted by the investigating detective as a reason for unfounding. So I want to emphasize that we did not assume that complainants who recanted their testimony had filed a false report. A case in which the complainant recanted was categorized as a false report only if there was independent evidence that a crime did not occur. And there was no indication in the case file that the complainant's recantation was motivated by fear, pressure, or a belief that prosecution would not be in her best interest. So as shown on this table, which I think you probably can't see all of because of the pictures on the side, but I think you can get the gist of it. So we categorized 2/3 of the unfounded cases as false reports, either because the complainant recanted and there was evidence that a crime did not occur, there were 31 of these cases, or because there was evidence that the crime did not occur, or no evidence that the crime did occur, even though the complainant did not recant, and there were 24 of these cases. An additional 5 cases were determined to be baseless but not false. And there were only 10 cases were deemed to be not false reports. 8 of these were cases in which the complainant recanted, but there was clear evidence that her recantation was motivated by fear, threats, or a lack of interest in the case. And only 2 of these cases were cases in which the complainant did not recant, and there was evidence that a crime did in fact occur. We were unable to categorize the remaining 11 cases as false reports or not, and 8 of these were cases where the research team felt that the LAPD should have investigated further before closing the case, that there was evidence that wasn't followed through on, or witness statements that weren't followed up on. And then 2 were simply cases that we were unable to categorize for various reasons. So the second objective of this particular study was to determine, well, what predicts whether the detective investigating the case will unfound the complaint? And we used the quantitative data from case files for a sample of rape and attempted rape cases that were handled by the LAPD in 2008. The dependent variable was a binary variable that was coded 1 if the case was unfounded, even if we had determined that it was not a false report. We were just looking at how the detective cleared the case. And then it was coded 0 if the investigation was continuing, the case was cleared by arrest, or the case was cleared by exceptional means. Because we collected data from the case files on more than 250 variables, we were able to control for detailed information about the victim, the case, and the strength of evidence in the case. And evidentiary strength is one of those variables that few studies of prosecutorial decision-making in particular, but also of police decision-making, few studies have those kinds of measures. Let me just point out a couple of different things. For victim characteristics, we included age, race, ethnicity, relationship to the suspect, But we also coded for risk-taking behavior by the victim, such as hitchhiking or drinking alcohol or using illegal drugs. Questions about the victim's character or reputation. Most of these involved victims who worked in disreputable, what one might call disreputable occupations, or victims who had criminal records. Whether the victim had a mental illness or mental health issues, and then whether the victim had a motive to lie and recanted the allegations. Indicators of case seriousness are, I think, the usual suspects. Strength of evidence, we controlled for whether the crime was reported within 1 hour, the number of witnesses, whether the victim was willing to cooperate in the investigation and prosecution of the crime, and whether there was physical evidence of assault. Not surprisingly, the strongest predictor by far was whether the victim recanted the allegations. Of the 55 cases where the victim recanted, all but 7 were unfounded. But several other victim characteristics also predicted the likelihood of unfounding, even after taking into account whether the victim recanted. The report was more likely to be unfounded if the victim alleged that she was assaulted by a stranger versus an intimate partner. If the victim had a mental illness or mental health issues that might have called her credibility into question, and if there was information in the case file that raised questions about her character or reputation. The only other variables that affected the likelihood of unfounding were whether the victim suffered some type of collateral injuries, and if there was physical evidence, both of which served to corroborate the victim's allegations. So one thing to point out is that recantation by the victim, while obviously important, was neither a necessary nor a sufficient condition for unfounding the complaint. Some cases were unfounded even though the victim did not recant, and some cases were not unfounded even though the victim did recant. And the comments of the detectives we interviewed confirm this. One said, "I do believe that there are recantations that are lies. For me, it would indicate the victim clearly indicating that she lied, providing a rational motivation for lying, and I believe her when she says it didn't happen." Another, "Many victims recant because they are tired of dealing with it and they want to go back to normal and feel responsible for the stress that has emerged." And a third detective said, "If the victim says that it did not happen and I don't believe her, I still present it to the DA and let the DA decide. They will reject it, of course." But some detectives said the case could be unfounded only if the victim recanted, which is not true. For example, one detective said, "The only way we can unfound is if the victim tells us it did not happen. There is no other way." And some detectives stated that they would always unfound if the victim recanted. When the victim says, "I made a false report," it gets unfounded. Moreover, a number of detectives, actually quite a few, stated that they commonly use techniques designed to, quote, "get the victim to recant," or to break her down and admit to what she was really doing. So because the 81 unfounded cases were not a random sample of all cases reported to the LAPD in 2008, we were unable to use the unweighted data to determine the proportion of all 2008 reports that were actually false reports. To do this, we used data that were weighted by the factors used to select our stratified random sample. And using these data, we determined that 4.5% of all cases reported to the LAPD in 2008 were false reports. And this is consistent with Longsway et al.'s conclusion that estimates of false reports narrow to a range of 2 to 8% when they're based on more rigorous research. So one conclusion that can be drawn from these data is that the LAPD was clearing sexual assault cases as unfounded appropriately most, but not all of the time. Stated another way, about 3/4 of the cases that were cleared as unfounded were cases in which there was evidence that a crime did not occur and that the complainants, for various reasons, either filed false or baseless reports of sexual assault. But it's also important to point out that we determined that 10 of the 81 cases were cases in which a crime did occur, and therefore the case should not have been unfounded. Our data also revealed that recantation of the complainant is not required to unfound the case. Nonetheless, our multivariate analysis revealed that recantation by the victim is a powerful predictor of the detective's decision to unfound the case, but that other factors also played a role. So in conclusion, unfortunately, women and girls do lie about being raped, but the rate of false reports is low. It's approximately 4.5% in Los Angeles. Nonetheless, this is a serious problem because false allegations undermine the credibility of the so-called genuine victims and divert scarce resources from investigation of the crimes against them. I think false allegations also feed into detectives' cynicism about sexual assault cases and cause them to be I think, unnecessarily suspicious about some of these allegations. Oops. So moving on to the second study, this is our study on disentangling police and prosecutor decision-making in sexual assault cases. So as this slide makes clear, there is substantial attrition in sexual assault cases reported to the police in LA. Very few sexual assault reports lead to the arrest, prosecution, and conviction of a suspect. In fact, of the 5,031 reports to the LAPD during this 5-year period, only 390 or 7.8% resulted in a conviction. It's also important to point out that although 45.7% of the cases reported to the LAPD were cleared or solved by the police for UCR reporting purposes, only 12.2% of them were cleared by arrest. And fully a third of these cases were exceptionally cleared. And I'll talk a little bit more about that in a moment. So these data suggest that the locus of case attrition is the decision to arrest a suspect. Only 616 of the more than 5,000 reports of sexual assault to the LAPD resulted in the arrest of an adult. Actually, it's 594 resulted in the arrest of an adult suspect. Although researchers often conceptualize prosecutors as the gatekeepers of the criminal justice system, I think in the case of sexual assault, the real gatekeepers are the police. The problem, as we discovered, is that it is not quite that simple. As we discovered in Los Angeles, the decision to arrest the suspect, although formally within the control of law enforcement, reflects decisions made by both police and prosecutors. Similarly, the decision to file charges against the suspect is often made before the police make an arrest. So we began this process by assuming, as have most researchers who've studied prosecutorial decision-making, that the decision-making process was linear. The police would conduct an investigation, and if there was probable cause to make an arrest, they would arrest the suspect and present the case to the prosecutor for a formal charging decision. The prosecutor would then either file charges against the suspect or reject the case for filing. In other words, we began our project with an assumption that law enforcement's decision to arrest and the DA's decision to file charges were separate decisions that reflected different standards of proof and different decision rules. What we discovered was a much more complicated process. Some cases followed the traditional linear pattern in which the police investigation leads to arrest, and that leads to a formal charging decisions. But in other cases, and as it turned out, these were weak or problematic cases for a number of reasons. These cases involved overlapping decisions of police and prosecutors. So in these cases, the police would investigate the crime, and if they had probable cause to make an arrest, but were concerned about the likelihood of a successful prosecution, they would present the case to the prosecutor for a pre-arrest charge evaluation. If the prosecutor decided, yeah, this is a case that we would likely file, the police would then make an arrest and present the case to the prosecutor for that formal charging decision. However, if the prosecutor decided that they would not file charges in the case based on the evidence presented at the pre-arrest charge evaluation, the detective really had two options. The detective could investigate the case further, and if additional evidence was obtained, could then make the arrest. However, this rarely, if ever, happened. Instead, if the prosecutor said, no, this is a case that we would not be filing charges in, the detective would not make an arrest, but would clear the case by exceptional means. So let me illustrate this, how these decisions overlap with one of the cases that from our 2008 review of case files. So in 2008, the Los Angeles Police Department received a sexual assault report from a 13-year-old girl who was a runaway and who stayed with various friends, all of whom, including the alleged suspect, were gang members. One night, the complainant and a female friend were invited to a party at the residence of one of the gang members. The complainant, who admitted drinking more than 10 beers and smoking marijuana while at the party, told the investigating officer that one of the males at the party offered to let her sleep on the fold-out couch in his living room. She stated that she fell asleep and awoke to find the suspect on top of her. She said that the suspect touched her breast, rubbed her buttocks, and penetrated her rectum. She stated that she told the suspect that it hurt and that she told him to stop. The complainant's forensic medical exam revealed evidence of acute anal trauma, and the suspect, who lied about his gang affiliation and who had a criminal record, was identified by the victim through a photo lineup. When the suspect was interviewed by the police, he denied assaulting the complainant, saying that he went straight to bed after the party and that his father would confirm this. So the LAPD did not arrest the suspect. Rather, the investigating officer presented the case file to the district attorney's office for a pre-arrest charge evaluation, despite the fact that the nurse who conducted the forensic medical exam noted in her report that, quote, sexual abuse is highly suspected, unquote. The district attorney screening the case refused to file charges, citing insufficient evidence to meet their standard of proof beyond a reasonable doubt. On the charge evaluation worksheet, the district attorney noted this: victim is a runaway who gives inconsistent and unlikely versions of her adventures. No evidence of any assault taking place. The defendant has a witness who corroborates his version. The investigating detective then cleared the case by exceptional means. The fact that the prosecutor used the phrase "her adventures" to describe the complainant's behavior on the night of the alleged sexual assault, and stated that the complainant's testimony was both inconsistent and unlikely, indicates that the prosecutor was concerned about the complainant's credibility as a witness. The prosecutor's statement that there is, quote, "no evidence of any assault taking place" is clearly incorrect, as the medical exam report cited anal trauma, anal bleeding, and anal laceration, all of which would be consistent with the complainant's allegation that she was sodomized. Finally, the prosecutor failed to note that the witness who could corroborate the suspect's version of events was the suspect's father. So in this case, it very clearly illustrates the overlapping roles of police and prosecutors. Although there was an identified suspect and appeared to be probable cause to make an arrest based on the results of the victim's forensic medical exam, the investigating officer did not arrest the suspect. Rather, the officer presented the case to the district attorney, and when the district attorney determined that there was insufficient evidence to file charges, the detective cleared the case by exceptional means. The suspect in this case was not arrested, in other words, because the district attorney determined that the evidence was not sufficient to file charges against the suspect. At least in this jurisdiction, law enforcement officers clear a substantial portion of sexual assault cases by exceptional means when the district attorney reviewing the case determines that the evidence does not meet their filing standard, which is proof beyond a reasonable doubt and a reasonable likelihood of conviction at trial. The result of these overlapping decisions is that a significant proportion of cases in which the police appear to have probable cause to make an arrest do not result in the arrest of the suspect, and that a substantial number of cases are rejected for prosecution before the police even make an arrest. So the objectives of this particular study were to examine these overlapping decisions and identify the predictors of the decisions using multiple indicators of arrest and charging decisions. So a little bit about UCR guidelines on clearing cases. According to the Uniform Crime Reporting Handbook, offenses are cleared or solved either by arrest or by exceptional means. And the handbook states that an offense is cleared by arrest if solved for crime reporting purposes when at least one person is arrested, charged with the commission of the offense, and turned over to the court for prosecution. Regarding exceptional clearances, the handbook notes that there may be occasions where law enforcement has conducted an investigation, exhausted all leads, and identified a suspect, but is nonetheless unable to clear the case by arrest. In this situation, the agency can clear the offense by exceptional means, provided that they can answer each of these 4 questions in the affirmative. Has the investigation established the identity of the suspect? Is the exact location of the suspect known? Is there enough information to arrest, charge, and turn over to court for prosecution? In other words, is there probable cause? And finally, is there something beyond the control of law enforcement that precludes them from arresting the suspect? To illustrate the types of cases that might be cleared by exceptional means, the handbook provides a list of examples, most of which involve the death of the suspect or an offender who is unable to be arrested because he or she is being prosecuted in another jurisdiction for a different crime, or because extradition has been denied. One of the examples provided is when the victim refuses to cooperate in the prosecution, but there's an added proviso which states that this alone does not justify an exceptional clearance, and that the answer must also be yes to the first three questions that are outlined on this slide. So the data for this study involve rape and attempted rape cases that were reported to the LAPD or the Sheriff's Department, in which the police knew the identity of the suspect. And so of the original 650 cases, there were 530, or just over 80%, in which the police knew who the suspect was and where the suspect was located. There were very few victims who were not white, Black, or Hispanic, so we eliminated 31 victims who were Asian American or another race. And this left 491 cases. So our dependent variables are measures of decisions made by police and prosecutors in sexual assault cases. Beginning with the decision to arrest, we conceptualize this decision in two ways. And the first is a dichotomous measure of whether the case was officially cleared by arrest. And the second is a dichotomous indicator of whether the suspect was arrested. As we explain in our paper, both the LAPD and to a lesser extent, the Sheriff's Department changed the case clearance category from cleared by arrest to cleared by exceptional means in cases in which they make an arrest, but the district attorney does not file felony charges. This seems totally bizarre that they do this, and they didn't really have a good explanation for why they changed the case clearance type. So focusing only on cases that were cleared by arrest, in other words, would mean that not all cases that resulted in the arrest of the suspect are counted as arrest. And our third dependent variable, and the one that we think is the most interesting, is whether the investigating detective presented the case to a deputy district attorney for a pre-arrest charge evaluation. And we also conceptualize the decision to file charges in two ways. The first, which is the conceptualization used by prior research, examines charging outcomes only for cases that resulted in the arrest of the suspect and were then presented to the DA following the suspect's arrest for a filing decision. And the second, which we argue more accurately captures the decisions that prosecutors actually make, examines charging decisions in all cases that were presented to the district attorney for a charge evaluation, regardless of whether the suspect was arrested or not. So the independent variables that we use in this part of the analysis are the same variables that we used, in our study of the unfounding process, so I won't go over those now. Before I provide the results of the analysis, I'd like to show you data on case outcomes that illustrates the prevalence of the overlapping decisions of police and prosecutors. As shown on this table, 147 of the 357 cases were presented to the district attorney before the suspect was arrested. So about 40% of the cases were evaluated by the prosecutor prior to the suspect's arrest. The other 210 cases, or 60%, were cases that were evaluated after the suspect's arrest. What's interesting is that of the cases presented to the prosecutor before the suspect's arrest, the ADA filed charges in only 9 of these cases. By contrast, of the cases that were evaluated by the prosecutor after the suspect's arrest, about half of them resulted in the filing of charges by the prosecutor. Also, of the 138 cases that were rejected by the prosecutor at the pre-arrest charge evaluation, 135 of them were cleared by exceptional means, and 3 of them were unfounded. So one consequence of presenting cases to the DA for a charge evaluation prior to arresting the suspect is that it means that in these cases, the decision to arrest or not is made not on the basis of probable cause, but on the basis of the DA's filing standard, which is proof beyond a reasonable doubt and a good likelihood of conviction at trial. None of these cases, only 9 of these cases that were evaluated in the pre-arrest charge evaluation resulted in the arrest of the suspect and the filing of charges. So the discrepancy in outcomes for cases reviewed by the prosecutor before and after the arrest of the suspect suggests that detectives present problematic cases to the prosecutor prior to making an arrest with an expectation that charges will be rejected and the case can be closed by exceptional means. In fact, several of the detectives we interviewed admitted that if the case is the classic he said, she said case, and there's no corroboration of the victim's allegations, they would, quote, take it to the DA to get a reject. So here's some comments from assistant district attorneys and detectives. Prosecutors said, so if they know we won't file, they won't arrest. And another said, if we reject at the pre-filing interview, they usually won't make an arrest because we won't be filing the case. A detective said, weaker problematic cases are taken to the DA's office to let them decide. And similarly, sometimes if we're unsure, we have what we call drop-offs. We present the paperwork to their office and they'll tell us what to do. Although a number of respondents, especially district attorneys, justified pre-arrest charge evaluation as a means of ensuring that the evidence was solid before the suspect was arrested, many detectives acknowledged that they presented cases to the district attorney before arresting the suspect with the expectation that the case would be rejected for prosecution. This suggests that pre-arrest charge evaluation is being used not to ensure that all the I's are dotted and the T's are crossed, but to dispose of weak or problematic cases. This is confirmed by the fact that the DA filed charges in only 9 of the 147 cases screened prior to the suspect's arrest, and that all but 3 of the 138 cases rejected during pre-arrest screening processes were cleared by exceptional means. These cases were not investigated further to ensure that all the I's are dotted and the T's are crossed. So in the interest of time, I'm just going to focus on the results presented in the 3rd column of this table, which identifies the predictors of the police decision to present the case to the prosecutor for a pre-arrest charge evaluation. As shown in the 3rd column of the table, only one victim characteristic, whether the victim engaged in any risky behavior at the time of the alleged assault, influence whether the case would be presented to the district attorney for a pre-arrest charge evaluation. The odds of a pre-arrest charge evaluation also were affected by 2 indicators of crime seriousness, whether the charge was rape and whether the suspect used a weapon, and by 4 measures of evidentiary strength. So the likelihood of a pre-arrest charge evaluation was significantly lower for cases in which the victim reported the crime within 1 hour, cases in which the victim was willing to cooperate in the investigation and prosecution of the case, cases in which there was some type of physical evidence, and cases in which there were more witnesses. The results of our analysis of the 2 charging decisions, of the charging variables, which are shown on this slide, reveal that different factors also affect these outcomes. Beginning with the more traditional conceptualization of charging decisions that follow the arrest of the suspect, only 3 variables affected this outcome: the victim's age, whether the victim had a motive to lie, and whether the victim was willing to cooperate. Although our broader definition of charging, which includes charging decisions made before or after the arrest of the suspect, is affected in the same way by these three variables. It also is affected by the victim's risk-taking behavior, whether the most serious charge was rape rather than attempted rape, whether the suspect used a weapon, whether the victim resisted verbally and physically, reported the crime within 1 hour. So what are the policy implications of this pre-arrest screening process? At least in this jurisdiction and for this type of crime, a substantial proportion of cases in which a suspect was arrested were not cleared by arrest. This occurred when the district attorney reviewing the case following the arrest of the suspect rejected the case for prosecution, and the detective investigating the crime changed the case closure from cleared by arrest to cleared by exceptional means. Moreover, a significant number of cases were evaluated and rejected for prosecution by the district attorney prior to the arrest of the suspect. Defining the decision to arrest as cases that were formally cleared by arrest and operationalizing the charging decision as cases that were evaluated following arrest is misleading, as doing so undercounts both types of decisions. It also, I think we conclude that it results in overuse, actually misuse of the exceptional clearance. It subjects the decision to arrest to a higher standard than is required by law and effectively gives the prosecutor some control over the decision to arrest. Moreover, failure to arrest in spite of probable cause to do so means that the suspect is not held accountable for his behavior and that the behavior does not become part of his criminal record. And finally, it denies justice to victims who made the decision to report the crime to the police and are willing to cooperate as the case moves through the criminal justice system. So what does all this tell us about the response of the criminal justice system to sexual assault and sexual assault victims in the 21st century? It has been almost 4 decades since every state adopted legal reforms designed to prompt more victims to report to the police and to increase the odds of arrest, prosecution, and conviction. Sadly, it seems that the more things change, the more they stay the same. Our study revealed that sexual assaults reported to the police in Los Angeles had very high rates of case attrition. Very few cases result in arrest, prosecution, and conviction. The result is that, as was the case in the era preceding rape law reform, only, or at least primarily, crimes perceived as real rapes involving genuine, or in the vernacular of the LAPD, righteous victims, are taken seriously by the criminal justice system. This, like the study that Julie Horney and I conducted in the early 1990s, suggests that the rape reform movement produced largely symbolic as opposed to instrumental change. As evidence of this, consider the fact that in the 3rd decade of the 21st century, 21 years after the US Senate hearing to discuss the systematic failure of law enforcement in responding to sexual assault cases, we're still talking about the inadequate response of the criminal justice system to the crime of sexual assault. Sexual assault within the context of intimate relationships, sexual assault on college campuses, and sexual assault in the military are all, once again, on the public and political agenda. The question, of course, is why the response of the criminal justice system to the crime of sexual assault has not improved, at least not by much, in the past half century. Why, in 2021, are we still talking about legitimate rapes and righteous victims? And with that, I will conclude my presentation and be more than happy to answer any questions you might have.
Well, let me lead with one question here. So in 2017, you were appointed to the Department of Defense Advisory Board on investigation, prosecution, and defense of sexual assault in the armed forces. How do you see your research fitting into this work for the Department of Defense?
So that's an interesting question, because I started out, before I was appointed to the advisory board, I was actually a consultant to the commission that preceded the DAC IPAD, and helped them with their statistical analysis of sexual assault cases reported to the armed forces over a several year period. And I think that my work came to the attention of the people who are making these kinds of decisions, because it's some of the only work that really looks at both police and prosecutorial decision making in sexual assault cases, which is and the Department of Defense was looking for someone who had some expertise on these issues and could advise them about the appropriate way to analyze their data, what are the relevant control variables and that kind of thing. So I think that my work did, obviously did play an important role in my coming to the attention of the Department of Defense. If that's a good thing or a bad thing, I don't know, but.
So I have another question. Do you think that including demographics or other characteristics of the officers or prosecutors could reveal anything additional? And as a second part of that question, the race of the victim as well.
So we did look at the race of the victim, and there were a substantial number of Latina victims and also African-American victims in our sample, and neither the race of the victim nor the combination of the race of the offender and the victim had an impact on the outcomes that we were looking at. Which I think that's a very positive finding, because prior research has shown that, in particular, Black men accused or convicted of assaulting white women are treated much more harshly than other race of victim, race of offender combinations. We did interview a fair number of female detectives and district attorneys for this, for our study. And I don't think that we could say that there were clear gender differences in the responses that we received from either police or district attorneys. Whether the race of the prosecutor or the detective would have any impact, I don't know. That's something that I don't believe anyone has looked at. I mean, it certainly could have an impact, especially in terms of establishing rapport with victims who are non-white, for example, if the detective or the prosecutor is also non-white, but that's not something that we looked at, but it's obviously a very interesting, important question.
Okay, so this is a question from an audience member.
Okay.
What is your observation about the degree of variation across jurisdictions in policing practices? And are they largely the same, or some jurisdictions do better than others?
So one of the things that happened after the publication of some of our work, and in particular after the publication of our book in 2014, is that a lot of journalists got very interested in this concept of cleared by exceptional means. And ProPublica and NPR did a series, I think a three-part series on the mishandling of sexual assault cases. And they requested, through the Freedom of Information Act, information from the largest police departments in the United States on the proportion of cases that were exceptionally cleared. And the numbers were astonishing. They ranged from about 60 to 70% of all reports cleared by exceptional means to some jurisdictions that used it very sparingly. I just had a phone conversation with somebody from Sacramento where they did a Freedom of Information request, and they found out that 90% of the reports reported to the sexual assaults reported to the Sacramento Police Department were cleared by exceptional means. And when the journalist tried to get the people in the Sacramento Police Department to talk to her about that, they absolutely refused. They would not talk about it. And so I think this is one of the things that our research sheds some light on, is this practice of clearing cases or solving cases, but not really solving those cases. One of the deputy police chiefs in LA referred to it as solving cases with an eraser. And the reason that police departments can get away with this is because when the UCR reports case clearance data, they combine cases cleared by arrest and cases cleared by exceptional means in one case cleared statistic. So for example, the Los Angeles County Sheriff's Department cleared a whopping 88% of its cases during the 5-year period that we looked at. And so you look at that and you say, wow, they cleared 88% of their cases. That means they solved these cases and made arrests. I mean, that's what the average person looking at that data would assume. But in reality, they only made arrests in about 30% of those cases, and over half of them were cleared by exceptional means. And so it's very misleading to combine both of those things into one statistic. And one of the recommendations that Kate and I made in our book was that the FBI disaggregate that data so that it's more transparent how police departments are handling these cases. So it's sort of a long-winded response to the question. I do think that this is used with, it's variable, but a lot of police departments use the exceptional clearance. And there's been some research showing that it is primarily used for sexual assault and domestic violence cases.
Okay, I have another, I think, audience question. Can you speak to how your findings might be applied to male victims of sexual assault, a group that is probably more reticent in terms of reporting?
Right. So we made a conscious decision to only focus on female victims in this study. But I think that looking at case outcomes for male victims is obviously important. One of my doctoral students is doing a vignette study trying to determine whether the myths that surround rape involving male victims are the same or different than the myths that surround rape involving female victims. I suspect that we would find similar, but perhaps more pronounced effects if we looked at male victims. That is, more victims who are not willing to cooperate as the case moves forward, and more use of the exceptional clearance. I mean, one of the things that I didn't talk about, but the only variable that affected all 6 of the outcomes we looked at was whether the victim was willing to cooperate. And I think that's a complicated concept in and of itself, because victims can decide not to cooperate for a variety of reasons, including pressure from police and prosecutors, who might tell them that, this case is, it's a loser, it's not going anywhere, you're going to get torn apart if it goes to trial, and so on.
Okay, so I have one last question here.
Okay.
What do you think is the next step in this line of research? What should researchers be focusing on in the future?
Yeah, so, I think that the most startling thing to me, as someone who's done a lot of research on prosecutorial decision-making, was this notion of the pre-arrest charge evaluation. And I think that we need to know more about that, because we don't know, is this something that is unique to sexual assault and crimes like that? Or is it something that happens with some degree of frequency, regardless of the kind of crime? The district attorneys we talked to in LA, as I said that it primarily happened with sexual assault and domestic violence cases. But it's certainly something that I think deserves more attention from scholars. And I think that, thinking about how prosecutors make decisions and focusing only on those decisions that they make after a suspect has been arrested is really very misleading. And, I think that there needs to be more investigation of that process, both in sexual assault and in other kinds of cases. And I think we didn't do any analysis here on, what happens to those cases where the prosecutor does file charges. And that's obviously important as well. How many cases result in convictions? What sorts of sentences are imposed on those who are convicted? And are the variables that impact those decisions legally relevant or legally irrelevant variables? So lots to do for graduate students who are looking for research projects.
Well, that was just terrific, Cassia. Thank you so much for doing this.
My pleasure.